ready.
Right, carry on.
Dry run.
Practice.
Otherwise, if able. Appeal in the matter of Water Plus Ltd and Brendon International Ltd.
Yes, Mr. McGrath. Have you and Mr. Steinmetz had an opportunity to discuss the division of time?
We have, my lord.
What do you envisage? How do you envisage the time?
I've told Mr. Steinmetz that I will have sat down by lunchtime. Precisely how long before lunchtime may depend on the extent of judicial interventions during my submissions.
Well, it sounds as though we're going to be able to finish today, which we have to do. But thank you very much. Well, thank you very much for your contributions so far. We've read, obviously, the judgment, the skeleton arguments. We haven't, or for my part, I haven't dipped into the authorities. I haven't, as yet, looked at Garner's law on sewers and drains. But no doubt will take us to the relevant passages from that in due course. But we think we're pretty familiar with the essential arguments of fact and law.
I'm grateful, my lord. I was proposing to deal with matters under 3 headings. I was going to make various introductory remarks and in the course of that turn up some of the key statutory provisions.
Yeah.
Then I was going to go on to address ground 1 of the appeal, and I'm proposing to deal with that itself under 3 headings. First of all, the question of law as to the incidence of the burden of proof.
Yeah.
Secondly, how in my submission the judge's error on that then pervades his approach to the facts and why his fact-finding can't stand in light of that error. And thirdly, the question of the exclusion of the evidence of Mr. Griffiths.
Mr. Griffiths. It's just Mr. Griffiths we're concerned with.
It's only Mr. Griffiths.
You will no doubt you will explain exactly why that is. Yes, and then the third presumably ground.
My lord, if I can address that now, in terms of the evidence that was excluded, in my submission, that's the only one that actually really makes a difference.
Okay, because there was quite a lot of exclusion.
There was. The rest of it...
quite a lot of the judgment is about that.
It is indeed, my lord. Aside from the evidence of Mr. Griffiths, in my submission, none of that makes any difference to the judge's fact finding.
And then your third is ground 2 limitation.
Ground two limitation, precisely, my lord, where I propose to set up a proper test, look at the evidence, and then address what I say are the errors in the judge's approach.
Yeah.
I can start then with the introductory remarks. And first, can I show the court the sewer we're arguing about? To orientate the court around the facts. There's a plan of it. I say the sewer, a plan of the sewer, I should say. Yes. There's a plan of it at tab 12 of the supplementary bundle. This is a document more easily seen in landscape. And towards the top, there is a property enclosed with a red line. That is the claimant's property. And then there is a dotted line coming south from that and then turning to the east. And at a crossroads, does your lordship see it meets a solid blue line with the numbers 225 above it?
Yes.
That solid blue line is the sewer. So it goes in a southeasterly direction along the road, turns with the road, around a corner to the south, and then away across some open ground under a canal, and finally discharges into a watercourse that one can just see
Yes.
peeking around the end of the plan.
Yes.
So what does the dotted line indicate? You said the solid blue line was.
The solid blue line is the sewer. Those dotted lines are drains or sewers that come from the other properties. And there in fact may be a dispute that could be had about the extent to which, if the solid blue line is a public sewer, some of those are public sewers. That's irrelevant for present purposes.
So the water's discharged from the property into that dotted line, whatever that is,
Indeed.
and then that goes into the sewer,
And that goes into the sewer.
and that goes into the sewer, and that goes into the water course at the bottom.
Indeed, my lord.
Thank you.
So the sewer literally begins and ends in the manner we see. So just above where it starts, it seems to be fed into by another sewer. Is that right?
That seems to be the case, my lord. Quite what's going on there, I'm not certain, because I think there's a bridge over the railway, so the land must go uphill. So there must be a limit to how much is fed into there.
So there are quite a lot of red and black dotted lines on this plan. Are they all, as it were, other sewers draining into the sewer?
Indeed, my lord. I mean, what was common ground at trial, I think, was two things. First of all, the roadways were all owned by the council. And secondly, the other properties surrounding the road that the sewer is on have been sold by the council but drain into that sewer. So the sewer serves multiple properties, not owned by the council.
The road under which the sewer is, you say, is accepted as a public road? Or as
No,
a
it's
local
not.
authority owned?
It's local authority owned. It was accepted, it was built
Never
to a adoptable
adopted.
standard. But yes, the evidence as it came out was that it was never adopted.
Yeah.
And is that also true, or is it accepted in relation to the road across the crossroads?
The road across the crossroads is the same, my lady.
Okay.
I think, from recollection, I think the public highway ends about the railway, so everything beneath that is owned by the local authority but not adopted.
So it's called, goodness me, I can't really tell. It's something street.
What are you looking at? At the top.
It's, what is it? Sankey Street?
Sankey Valley was the name of the park, my lord.
Yeah, so Sankey Street is the road that we're looking at. Is that right?
I believe so, my lord.
I'll just read it. It's tiny text, but I think it's just below where it comes over the railway line. It says Sankey Street.
Sankey Street, yes, my lord.
So, is there anything else to look at about this, or is it just the plan? Have we got any photographs? I haven't
We
looked
don't
at.
have any photographs. I think that there were some at first instance, but
I mean,
that's
would
what we've got.
As a matter of interest, it may not be relevant. Would the sewer, is it the same in terms of construction as all these dotted line sewers?
There wasn't evidence on that I can recall, my lord. The evidence was that Mr. Griffiths' factual assessment was that it was built to a adoptable standard, so it was the kind of construction you'd expect.
I.e. the sewer.
The sewer, yes.
And when you said that the pieces of land either side of the sewer, is this right? You said were sold off, were developed by the local authority and then sold off.
Who developed them, again, wasn't in evidence, my lord. What we know about Brendon's site is that was sold off and then developed by Brendon.
Okay.
So, yes, but sorry, so just looking at it, there's something that's marked as Earlstown. It seems to be a sort of property or series of properties described as Earlstown, just to the
South.
right in the middle of the piece of paper, basically, just to the southwest, I suppose, of the start of the sewer, if I can put it that way. And then there's properties to the north, which aren't marked with anything. Is there any evidence about how those? What are those properties?
There are other industrial units. They were land sold off by the council, but there was no evidence as to the sequence of events in terms of when they were sold and when they were developed.
But all the roads here have dotted lines underneath them, don't they?
They do, my lord.
So okay, fine. Well, We mustn't get drawn into too many questions about the facts.
But any road, my lord, is likely to have some kind of drainage under it because one
Okay.
has, for example, highway drainage.
True. I see. Right. Yes. Thank you.
So that was the first introductory remark. And that plan in the supplementary bundle, to the extent, unless the court wants it on the desk, that can now be put away.
Well, that's the only page from the supplementary fund we're going to be looking at.
I will look at it in due course, but not for now. my lord.
Okay. Right.
Secondly, my second introductory remark, I want to draw out some important differences between a public and private sewer, in particular to stress the importance of this point more generally. And to do that, can I ask the court to turn up the first volume of the authorities at tab 8. These are provisions from the Water Industry Act 1991. That, my lord, is the statute governing water and sewerage industry.
Well, the judge in his judgment sets out the history of all this, going back to 1875.
Indeed.
It's quite interesting.
And I'm not going to go through that exercise again as time doesn't permit, but I'll endeavour to show some key points in these introductory remarks. But the 1991 Act is where we've ended up. And the notion of a public sewer comes in from section 219, page 95. And as this featured in the judge's judgment, without for now making submissions about it, if I could just observe 3 things about the wording of this section. First, it's headed General Interpretation. Secondly, section 2191 purports, as per the heading, to provide definitions. And thirdly, there is nothing express in this provision addressing the question of burden of proof in civil proceedings.
Well, it just says in this act, except insofar as otherwise context otherwise requires. So it's a set of definitions for the purposes of the act.
Indeed, my lady. The first relevant definition I have to show you, I can't dive straight in with public sewer, I'm afraid. I have to go to drain first, which is at page 97, which defines drains as a drain used for the drainage of one building or of any buildings or yards pertinent to buildings within the same curtilage. So a drain effectively is one building or one curtilage. Then the definition of sewer picks up on that, and that's at page 101. Whole page. Sewer includes, without prejudice to subsection 2 below, that's not material for present purposes, it expands its definition in certain places. All sewers and drains not being drains within the meaning given by this subsection, which are used for the drainage of buildings and yards of pertinence to buildings. So the statutory concept of a sewer is any pipe, if you like, draining one building. And then the definition of public sewer is one page back at page 100 in about the middle of the page. Which provides that a public sewer is a sewer vested in a sewerage undertaking's capacity as such. And then it gives out 3 routes to vesting, which I'll explain in a second. And that private sewer shall be construed accordingly. The 3 routes to vesting, I should say, I'll take the court to section 179 in due course. Schedule 2 to the Water Act.
Just a moment. Public sewers. Thank you. Yes, sorry.
Schedule 2 to the Water Act 1989. When the water industry was privatised in 1989, there were transfer schemes put in place so that all the assets transferred to the privatised undertaker. That's Schedule 2 of the Water Act 1989. And Schedule 2 to the Water Industry Act 1991 provides for what happens if you replace an undertaker. It's never happened as far as I'm aware, but if an undertaker loses its licence, a new company comes in, then one has a transfer scheme under Schedule 2. And Section 179 I will take the court to in due course. But that's what a public sewer is. It is a sewer vesting in the undertaker. And the judge describes some of the consequences of this in his judgment at paragraphs 24 to paragraph 30. Rather than ask the court to turn that up, I want to emphasise 3 that are of particular importance. The first 2 come or emerge under section 94 of the Act, which is at the very beginning of tab 8, page 44. and this is the general duty that all undertakers are subject to. And little a provides that undertakers must provide, improve, and extend such a system of public sewers, and so to cleanse and maintain those sewers as to ensure that that area is and continues to be effectually drained. So if it's a public sewer, it's up to the undertaker to maintain it. And then the second consequence comes under little b, which provides that the duty is to make provision for the emptying of those sewers and such further provision as is necessary from time to time for effectually dealing by means of sewage disposal works or otherwise with the contents of those sewers. So if it's a public sewer, the undertaker has to deal with its contents. Member of the public can put whatever in there, it's up to the undertaker to deal with it. And the third important consequence, my lord, comes under section 106, which is at page 66, which is the right to connect, as it's called, right to communicate in the statutory language. And that provides a right for the owner or occupier of any premises or of any private sewer which drains premises to connect into a public sewer and to discharge water through that sewer. And there are two things that I would ask the court to draw from that quick exposition of those provisions. First, public sewers, as the name suggests, are public assets. They are available for the public as of right, and they are maintainable. They are effectively centrally maintainable. And one's tempted to say at public expense, that's not entirely right, because it's private undertakers who maintain them, but they do so by means of charges levied and raised from the public. And secondly, my lord, while the question posed by ground one about the burden of proof in this particular case arises in the context of charging, it's a question which is capable of affecting all sorts of other disputes. So, for example, you might have a dispute over who's liable to maintain a sewer. A member of the public might say, this sewer on my road is leaking, undertaker, this is your problem. Or you might have a dispute over whether a person is entitled to use a particular sewer or whether it's a trespass. In which case, again, the question of the status of the sewer might arise. On the judge's reasoning, the judge's approach would apply in all of those cases. So my example of the member of the public trying to say that a sewer is public to force the undertaker to maintain it. On the judge's approach, the burden of proof would always be on that person in any dispute. So in my submission, that means that this really is, the question of law under ground one is a question of some general importance. And it also means that the invocation, both by the judge at paragraph 17 of his judgment and by my learned friend at times in his skeleton, of the apparent injustice in putting a burden of proof on Brendon when the matter is charging, is a point that really only goes so far.
So when, okay.
I was going to say that, can you remind me, which is the provision that requires a sewerage undertaking to maintain a list of public sewers?
That's section 199, my lord. I'm going to come on and show you that in my fourth introductory remark.
Right. Because, okay, fine. Well, I'll hold fire until then.
I want
So you're saying the burden of proof point applies across a number of potential disputes?
Indeed, on the judge's
on your interpretation, is the burden of proof consistently on one side or the other, whatever the dispute?
On the judge's approach, which derives the proposition that the burden of proof is on the person asserting a sewer is public from the terms of section 219. On the judge's approach, that must be consistent in any dispute in which the status of the sewer.
How about on your case? Is it consistent, or does it depend on the nature of the dispute?
In my case, the burden of proof will always be on the person who is asserting the status of the sewer as a necessary part, either of their cause of action or defence.
So, in the event of a claim for non-payment of charges,
it would be on me.
Thank you.
And I'll come on to that point by reference to Mr. Justice Burse's judgment, as he then was in Emmanuel and Everson, where he makes exactly the point that where the burden of proof is can just depend on who is the claimant sometimes.
Okay, thank you.
So that's a public sewer. I said I was going to draw the contrast with a private sewer. A private sewer, rather than being an asset available for the use of the public, is a piece of private property. I think strictly the position in property law is that it's part of the land in which it is. And therefore questions of liability to maintain it or of rights to use it are governed by ordinary principles of property law. So if you discharge into a private sewer that you don't own, it is prima facie a trespass or potentially a nuisance.
So all other things being equal, the sewer running under land owned by X would be owned by X.
It would, my lady, and strictly it'd be
X
wrong.
might be the local authority, but
Indeed, my lady. It would be wrong strictly to talk about the sewer being owned separately from the land because
it's
the
just
sewer.
part of it,
Indeed, my lady.
the fixture.
Indeed. Well, no, sorry, my lady. I said indeed. It's even more than that. It's more than just a fixture. It's actually part of the land.
Yeah.
So it's
Okay.
like if you build a brick wall, it doesn't become a fixture. It's part and parcel of the land. If I could then turn to my third introductory remark, which was to show the court some relevant vesting provisions. The first is section 179 of the 1991 Act, which is at page 89 of tab 8. Subsection 1 provides that every pipe, this I should say applies to both sewers and water mains, which is why it says pipe rather than sewer. It says every pipe which has been laid or constructed by a sewerage undertaker shall vest. So if the undertaker constructs the pipe, it vests immediately, it's never private property. And then subsection 2 provides that a sewer with respect to which a declaration of vesting has been made will vest. And I'll come on to that declaration in a second. And while I'm in this section, I should show the court as well over the page subsection 3, which provides that anything which in pursuance of any arrangements under section 97 above is done on behalf of a sewerage undertaker by a relevant authority within the meaning of that subsection is subject to any provision to the contrary contained in any such arrangements to be treated for the purposes of this section as done by the undertaker. So if a local authority is acting under section 97, which I'll go to in due course, and they either construct a sewer in that capacity or they declare a sewer to be vested, for the purposes of section 179, it's as if the undertaker did it and it vests in the undertaker. We've seen the concept of vesting mentioned. That comes about in section 102, which is at page 50. And that provides that an undertaker may at any time declare.
Sorry, which section? Where are you now?
Sorry, my lady, page 50, section 102.
This is about adoption.
This is about adoption, my lord. So that empowers an undertaker to declare that a sewer in their area is vested in them, or become vested in them. And there is no statutory formality for how you go about the vesting. All you need to do is declare it. And then under subsection 2, the court will see, there is an ability for the owner of a private sewer to say to the undertaker, please make a declaration of vesting in respect of our sewer. And that could be relevant, for example, if you have a housing development and the developer puts sewers under the roads, to take an example, and then sells off the houses, that developer will not want to be stuck with the sewer and any potential liability to maintain it. So it's open to them to go to the undertaker and say, please vest it.
And what does the undertaker have to do at that point?
Well, then there are over the page, there are two provisions I need to show your lordship in that respect. Over the page, subsection 5, there are various considerations that the undertaker is required to take into account in deciding whether or not to make a declaration of vesting. which centre on whether or not its part can be sensibly included in the undertaker's network and whether or not it's of a decent standard of construction.
And is it assumed that that anybody whose private sewer was subject of adoption in this way would never object to that?
I'm going to show your lordship that's going to be the second point in answer to my lordship's question. But the remedy of an owner either aggrieved with an adoption or aggrieved with a refusal to adopt comes under section 105, which is at page 62. And that's an ability to appeal to something called in the Act the authority. That's Ofwat, the regulator of the industry.
So if you were somebody whose premises drained into a private sewer, obviously in a sense that's you're self-contained. If the sewerage undertaking used the power of adoption, the consequence would be you would have to start paying for it.
Indeed, but if you're the owner of a property draining into the sewer rather than the owner of the sewer themselves, yes, you would not have a right to appeal under this section. You'd be lumped with it.
So these are people who, this is if you own a private sewer and the local authority either adopts it against your objection or doesn't adopt it when you want them to adopt it. So
Exactly.
this is the remedy you're showing us now.
Exactly, my lord.
Okay.
So you can always appeal to Ofwat in respect of that, of either a decision or a refusal. In respect to my lordship's concern, if I understood it properly, the person who owns the property discharging into the sewer but not the sewer themselves doesn't have a remedy under this section.
Do they have any remedy?
There is provision, I think, my lord.
Well, they might presumably have a private law remedy against the,
For not adopting?
no, for if they've got rights against the owner to use the sewer.
There's provision in subsection 6 of 102, page 51, which provides that they shall be entitled to use the adopted sewer to the same extent as if it had not been adopted. So that deals with the question of their use.
But they might have to pay for it.
But they might have to pay for it, my lord.
What's their remedy if they don't? If they think they shouldn't be paying for it?
There's none that I'm aware of, my lord.
Under the Act.
Under the
Under
Act.
the Act.
Do we actually need to get into this particular tributary?
And it's one, as the way I just phrased it might indicate, I'm afraid I had not myself bottomed out this tributary. I don't think anything turns on it for present purposes. I'm happy to go away and look at it more closely if the court would find that.
Well, none of it's not relevant to the appeal.
I'm grateful. That regime of construction causing vesting or adoption causing vesting, that's been the case since the 1st of October 1937, as the judge says in his judgment. The significance of that date is that it's when the Public Health Act 1936 was introduced, and that introduced the notion of adoption for the first time. Under the 1875 Act, there was a much more elaborate provision. And can I just briefly show the court that? Because again, this is relevant to the history.
This is relevant.
This is relevant.
Okay. Yes.
So under the 1875 Act, tab 1, and it's page 8, the relevant section. There was a very extravagant vesting provision. So all existing and future sewers.
Where are you reading?
From section 13, halfway down the page.
Sorry. On which page? Sorry.
On page 8, my lord.
Sorry.
Okay, second tab.
Extravagant, you say. Yes.
And what it says is all existing and future sewers within the district of local authority, together with all building works, materials and things belonging to, subject to certain exceptions, shall vest in and be under the control of such local authority. So it was a full-scale, effective nationalisation of sewers, apart from a limited category.
By a Conservative government.
By a Conservative government, indeed. A very radical Conservative government.
It was Disraeli.
Indeed, my lord. But that was to address the public health problems that are well known from the 19th century.
Yeah, yes, yes.
And that's how it was done. And there's various law on the way that this particular provision works, which needn't detain us for now, but that was obviously regarded as not a particularly great way of doing things, which is why in 1936, the 1936 Act, they abolished the concept of automatic vesting and went to the regime that we continue to have in place of, if you construct it, it vests, and you can declare that it is vested and adopt it, and then it vests. But sewers, I should say, that have vested under that provision, section 13, between 1875 and 1937, they continue to vest in undertakers.
By that time, the Chamberlain influence,
Indeed.
Conservative Party was stronger. Anyway, we digress.
No, strictly, I think wasn't Stanley Baldwin Prime Minister at the
He
time?
was, but he was. You're absolutely right. But Neville Chamberlain and his forebears had been. But moving
My
on.
lord. If I can then move to the fourth introductory remark, I just want to deal with the different actors that were involved in the process of vesting and pick up the question about records, look at the records they were required to keep over time. Section 13, which is open, you can see that it's local authorities in whom sewers vest. And back one page is section 5, which tells us who the local authorities are. They are urban sanitary districts and rural sanitary
And
districts.
urban district councils and rural district councils come in by this point.
I'm not sure, my lord. I think that may have been the 1890s, but I'm not certain.
Anyway,
But
the idea of urban and rural districts, a distinction between them. Are they terms of art, or is it just a general description of what was an urban district in 1875? Was it defined somewhere?
I'm not sure, my lord, I have to confess.
Okay.
I wouldn't want to answer that off the hoof. And we do have the definitions section, which doesn't provide a definition
I mean,
of either phrase.
just read it. We know what the metropolis is, but is it defined anywhere?
Yes, it is. Page 4. Although curiously not defined with a capital N, but that's a typo.
You're going to. That's a typo. Yes.
I'm keen on typos.
And there is a definition just below that of local government district.
Well, there were. Yeah.
But in any event, regardless of the overlap of existing bodies, they are constituted under this Act as particular authorities dealing with sanitary questions.
Mm-hmm.
But those are the actors for present purposes. And in terms of record keeping, if one skips forward to page 11, section 29, section 20, I apologise. An urban authority, but not a rural authority, is empowered but not required to create a map. So at this stage, there's no obligation with respect to record keeping, and indeed there's no power for a rural authority to keep a map. 1936.
Well, hang on, but it doesn't say that a rural one couldn't.
Well, say that they are local authorities, my lord, therefore they can only do what statute allows them to do, and the fact that urban authorities are empowered may be taken to imply that rural authorities are not so empowered.
We haven't nailed down the definition of urban and rural authority, have we?
We haven't, I'm afraid, my lord. I'm afraid I can't assist on that, I must confess.
Does it matter?
I don't think it matters, and the point is, it's local government. It's an extensive array of actors at local, nationally.
Which is
government.
that's been the theme throughout. Is that your point?
Up until privatisation. I'll come on to that, my
yes,
lord.
yes. Well, the judge covers this in a relatively short section of his judgment, doesn't he?
He does. I think taking it from what I had said in my skeleton argument.
I think he acknowledged that.
Can I move to the 1936 Act, my
Yes.
lord? Which is clearer about what local authorities are, so hopefully your lordship's concern is answered on that. It's tab 2, page 12, section 1. Which provides local authorities for the purposes of this Act. or the local authority, so subsection 2, local authority means the council of a borough, urban district or rural district. And then urban authority and rural authority are defined in the way
Yeah.
that one would expect. But there one sees the complete alignment between
Yeah.
the structures of local government and sewerage matters. In terms of record keeping, section 32 at page 22 now does apply a general duty. But it's not an absolute duty. Subsection 3 provides that it's not obligatory on the local authority to show on the map a public sewer which was vested in them before the commencement of the Act. And that, one can see the logic of that, because after the Act, the construction of the sewer, the vesting of the sewer is going to require some positive act by the local authority. Prior to the commencement of the Act, it could have been automatic under the provisions of section 13.
Still get typos in legislation, I'm curious. Third line.
Of what? Section 1, subsection 1.
Yeah. It's a map snowing.
That could just be
That may be a copy.
maybe a copying error. It's still a typo, but it's
Okay.
But appropriate for the weather today.
well, Lord Justice Snowden is very alert to that.
Yeah.
The next provision to show your lordship is the Water Act 1973. Now this created 10 water authorities who were put in charge of water and nominally sewage.
Still in the public sector.
Still in the public sector.
Right. So this is
And I say nominally sewage. I'll come on to that in a
we
second.
moved on to the Edward Heath Conservative government now. Haven't we?
We have indeed. And in fact, the Water Act,
Ebb and flow of yeah.
in fact, yes, all the great reforms happened under Conservative governments. But
This is all part of the local.
Sorry, with the sheer excitement, was this, so which tab?
this is tab 5.
So this is all part of the local government reforms. was it?
Indeed.
With the
The
Edward Heath
1972
government.
Act.
Yeah.
And it came into force at the same time as those
Yeah, okay.
reforms. It's all part and parcel of the same thing. And that under section 14 placed water authorities under duties with respect to sewerage. But I say that's nominal because if one looks at section 15, which is at page 27, it was the duty of a water authority and every relevant authority, which is a local authority, to make arrangements for the relevant authority to discharge as respects their area the functions of the water authority under part 2 of the 1936 Act. So, and that's the part dealing with sewage. So the water authority is required to delegate matters to the local authority. And in fact, the definition of relevant authority is subsection 10, which is at page 29, just makes clear that it is effectively local authorities.
Yes.
Privatisation then occurred in and sorry, I should say that there's no amendment at that stage of section 32 of the 1936 Act. So the duty to keep a record of sewers remained in force, and it remained a duty on the local authority, not on the water authority. Privatisation occurred in 1989 pursuant to the Water Act 1989. Some provisions of that are at tab 7. And the one material one for present purposes is at page 43, schedule 26, paragraph 47. And that, picking up on the point I just made, it requires a local authority who's got a map under section 32 of the 1936 Act to provide a copy of that to
Sorry,
the
I've
incoming
lost-
undertaker.
Which page are you on?
Page 43, my lady. Then moving to the present day provision for map keeping is section 199, as my Lord Justice Snowden referred to earlier, and that's at page 92 behind tab 8. And that places a duty to keep a map, but again, it's not an absolute duty. So across the page, subsection 7, the undertaker is relieved from the duty if they don't have any, if they don't know of or have reasonable grounds for suspecting the existence of the drain, sewer, or disposal main, or it's not reasonably practical to discover its course.
And this is in respect of only though of drain, sewer, or disposals laid before
1st of September 1989. So that's the date of privatisation, my lord.
Yeah.
And subsection 9, it's provided that the duties under the section are to be enforceable under section 18 above by the Secretary of State. So without getting into the vexed question of whether there could be a private law right under this section, there is an express provision for enforcement by the Secretary of State under the Act's enforcement mechanism. And the one final thing I should do in the statutes is show the court section 97 of the 1991 Act, which is at page 46. And that permits the undertaker, but doesn't require them, to enter into arrangements with the local authority for the local authority to discharge their sewerage functions. And the court has already seen how, if those arrangements are put in place and the local authority does something in that capacity, for vesting purposes, that's treated as if it was done by the undertaker itself. Now, in this case, the unchallenged evidence was that such arrangements had been put in place in the area we're concerned with until the early 2000s. And if I could ask the court to turn up the supplemental volume again, tab 6, page 46. This is the
Mr. Ashcroft's.
Mr. Ashcroft, indeed, my lord, and it's paragraph 13 in which he gives this evidence. Halfway down the paragraph, he says, in fact, the local authority continued its role as wastewater sewerage undertaker, acting as the agent up until the early 2000s. And then he goes on to make a different point, which I'm going to emphasise now. Some local authority records were good, others were not. Unfortunately,
sorry, I'm so where are you reading from?
From paragraph 13.
13. Sorry. Okay, hang on.
My lord. Unfortunately, they commonly contained many anomalies and errors. This is because the local authorities often drew things on their maps which were useful for them to know, but were not useful from a sewer mapping perspective. Sometimes sewers were incorrectly mapped or not mapped at all. And the reason that I emphasised that against the statutory background I've just been through is that the reality of the industry is that sewers have been constructed over a long period of time by a variety of different actors, not just undertakers. And undertakers, for the accuracy of their records, are dependent on both the quality, on the quality of both the record making and the record maintenance of those historic actors.
Well, except they can find out for themselves if there are any gaps, because they can presumably examine.
There are two difficulties with that when one is looking for a public sewer that is not shown on historic records, my lord. First of all, it's the sheer size of the network. And the evidence in this case, again unchallenged, was that United Utilities network alone is some 76,000 kilometres.
If I'm a utility and I want to charge somebody for the use of a public sewer, either it should be on my records, or I need to check that it's a public sewer because I shouldn't be charging them otherwise.
Well, my lord, again, I think the evidence deals with something like 7 million customers. So
That's just a lot of people, but for every person, I mean, I'm not sure what the submission is. I mean, I understand that records might be inadequate, but a sewage undertaking can't just randomly go around charging people without some basis for doing that.
The basis under the statute is that the property has to be connected to a public sewer.
Correct.
Uh,
So to pick up my lord's point earlier, if you are going to sue somebody for failure to pay a charge that you've levied on them, you would have to prove that they were using a public sewer.
Indeed, if we were to sue them, we would
Right,
have
and
to
if it
prove
wasn't shown on your map,
we would have to prove that the sewer they were using was public.
okay,
But the reason I make the point, my lord,
you couldn't say, yeah, but you know, maps are really inaccurate, so we can still sue you.
and that's certainly not my submission. That's not what I'm suggesting, my lord. The reason I make the point, my lord, is that it's important when one comes to consider the approach to the burden of proof, or rather to the evidencing of the status of a sewer, because insofar as the judge was imposing a standard on an undertaker that they must show how the sewer came to be vested, that's going to be something which in many cases is simply not going to be practicable. That's the reason I make the point.
But if it's not just to return to my question in a different context, if it's not practicable for you to demonstrate that it's a public sewer, you shouldn't be charging.
That wasn't what I meant to say, my lord. In that sense, I didn't say not practical to show that sewer is public. I said not practicable to show how it came to vest. So you might be able to say, well, that's obviously a public sewer because look, it's serving so many properties. It's under a highway. No one's paid anything. The utility company have maintained it for years. No one's ever challenged that. But if you ask us, when did this come to vest and how did it come to vest? We simply can't show that.
But can I just be clear about your way of going with the burden of proof? If the undertaker sues for the unpaid charges, where does the burden of proof lie?
On the undertaker.
If the occupier of the property pays charges and then says, "Oh, I've made a mistake, please give me my money back," where does the burden of proof lie?
That's me moving on to the second category. The answer to that,
The answer briefly.
the
so I
answer
know where you're
briefly
going.
is that it lies on the occupier, and the reason that it lies on the occupier is that their case is a case of mistake. In order to make out the cause of action, they have to prove mistake. In order to prove mistake, they have to prove that the sewer was private. Now, all the points that my Lord Justice Snowden just made to me, of course, would be relevant when it came to assessing the weight to be attached to different pieces of evidence, or indeed the absence of pieces of evidence when assessing whether or not the occupier.
But isn't there a joint two actions in which the occupier paid for some period but not other periods? So there was the occupier was seeking restitution in the same proceedings as the undertaker was claiming further charges. Where would the burden of proof lie?
Claim and a counterclaim. I had one of these earlier this year, and we settled before we could argue about the consequences of Brendon.
I'm surprised.
The answer is on the claim. On the claim, it lies on the occupier. On the counterclaim for fees, it lies on the undertaker. If the court decides that it can't reach a view on the burden of proof, both claim and counterclaim fail.
All turns on the burden of proof.
Well, we'll get on to that in due course, my lord. My learned friend's submission would be that the judge did not decide this case on the burden of proof. But we'll get on to that, and that brings me on to ground one of the appeal.
Okay, have we finished all introductory?
We have, my lord. Taken slightly longer than.
Well, you did anticipate interruption.
Can I just though just to pick up on the record keeping and the duty to maintain the records? I mean, the purpose for that is to enable members of the public to ascertain what is a public sewer. And it's certainly one of the reasons, isn't it? I mean, it's one of the purposes.
It is one of the purposes, my lord. Probably it has two other practically more important purposes. One, if you're thinking of building property and want to know where you can connect into, it's important to know where the public sewers are. And secondly, similarly, if you're developing property, the existence of a sewer under that property imposes quite serious restrictions on your ability to develop it. So again, it's important to know where a public sewer
But
is.
if I was facing a bill from a sewage undertaking for sewage services, and I went to the local authority, to the sewage undertaker's map, and didn't see any public sewer there, then prima facie, I would conclude, I would be entitled to conclude that I don't have to pay anything.
Indeed, and we'll come on to this underground too. When
Yes.
you buy a property, it's a standard search to look for drainage, and you get told whether there are
Yeah, I appreciate that, but the basic proposition as to why there's a publicly available map of public sewers is for the three reasons that we just discussed.
Those would certainly be three reasons. I wouldn't want to suggest they are necessarily exhaustive, but all three of them are important reasons, my lord. Can I turn then to ground one and first deal with the narrow question of where the burden of proof lies?
I suppose just out of as I've thought about it, I mean, do sewage undertakings usually bother to check against their own map whether there is a public sewer when they're charging somebody?
I'm at the risk of going beyond the scope of the evidence in this case, my lord.
But you would expect them to, wouldn't you?
I think it depends on the circumstances. And what generally happens when a new property is developed is that you get, as I understand it, and I say again, my lord, I'm going beyond the scope of the evidence in this case. Someone will ask for a water connection. That will bring the new property into charge, and then someone will look at it as to whether or not it should receive a sewerage charge.
But one of the curiosities of this case, unless I've misunderstood it, is that your clients were charging for supplying services through a sewer which, on their own map, wasn't shown to be a public sewer.
Again, there was no evidence of this, my lord, but one can make one supposition of how all that came about. If I could just go back to the plan very quickly, there's one point I didn't.
Tab 12 and then supplementary bundle.
Running alongside our solid blue line sewer, there is a thin brown line sewer. You can really see it when the sewer turns a corner.
It veers away from it at one point, doesn't it?
But it then veers away towards a red line.
Yes.
And that red line is a combined sewer, and the brown line, the scheme is that's a foul sewer. So properties round, and that red line presumably is a public sewer because foul sewage gets taken to sewage works. And the brown line, in fact, will be a public sewer under.
Hang on, sorry, I'm just not sure I'm following this. There are two brown lines I can see, one of which seems to end in the middle of a car park, and the other brown line seems to join up with a red line, which ends up on the face of it discharging into the canal.
The red line does two things, my lord, and there's the bit that goes into the car park. I think that must be a mapping anomaly. I'm not sure what that is, but
Another typo.
Presumably they don't dump sewage in the middle of the car park. What happens to the red line? Does your lordship see there's one bit that goes to the canal and there's another bit that continues down towards the bottom of the map? So, and this is my supposition, I must stress, not evidence, but the bit going into the canal, that presumably is combined sewer overflow. With combined sewers, they take both sewage in the traditional sense and rainwater. That means if you have a heavy storm, the sewer...
See news reports passing.
Exactly. So that presumably is one of those.
So what do we get from the fact that there's a sort of mysterious brown sewer running alongside the blue sewer?
So one could see that someone completely uneducated by anything we've discussed in this case, looking at just this, when Brendon first applied for a water connection, might have said, oh, well, look, there's a foul sewer there, which is definitely public, or definitely goes to the public, to public sewers. So it makes sense to bring this person into charge. And we know that Brendon were initially brought into charge for foul sewage, as well as surface water. And that could be how it happened. But, my lord, I'm engaged in an exercise of complete
That's
supposition.
speculation,
It's
isn't it?
complete speculation.
That's what you sort of wanted not to do previously.
I've been
You-
maybe
but
drawn
you-
into
you
it
asked.
from your
I did ask, yeah, but you, okay.
Well, the brown line, so the brown line starts at the same spot, does it? It starts, the brown line runs
You can
with
see
the blue
it's-
line,
Yes, it does. You can see with a little arrow.
the brown arrows. So it goes, and then
And then diverts at the bottom.
But if the statutory scheme was working properly, and I appreciate your point about records over history, but if the statutory scheme was working as it appears to be intended to work, the answer to whether you're properly being charged should lie in the records of the sewage undertaking.
On the one hand, but on the other hand, yes, but, my lord, if I can put it that way. But that's not a complete picture, and we'll come on to this with limitation.
yes,
Because, of course, occupiers have another very important protection, which is that when you purchase a property, the drainage arrangements are something that should be investigated in the purposes of.
and you would say looking at the confusion that exists in this area, it's an important inquiry made at pre-contract.
Indeed, my lord.
Yeah, but okay, I know you want on the facts of this case to move to limitation, but if I want to know today whether I'm being charged today appropriately, the structure of the statute appears to me at the moment to suggest that the answer should be found in the sewage undertakings records.
That's the only place under the statute that your lordship could go in that example.
And as I understand it, that's the case, even if, as in this case, the local authority was discharging those obligations for the water authority, effectively water undertaker, and may in fact not in all cases have handed over the right pieces of information. The obligation to keep the record, at least for post 1989 or whenever it is on the water undertaker.
That's correct, my lady, yes.
Even if there's 76,000 miles of whatever it is
Indeed.
of pipe. Kilometres.
It's one of the more general features of the 1991 Act that in some ways it imposes obligations on sewage undertakers which can never possibly be realistically be fulfilled. I think the Section 94 duty, for example, to effectually drain your area in the real world, that is never going to be fulfilled every day 100%, but that is the nature of the duty imposed. I don't shrink from that. Can I move then with that bypass into speculation? Can I move to ground one? And what I propose to do under my first part of ground one, which is the narrow point of the legal burden of proof, is set out the correct approach as a matter of law, address the judge's reasoning as a matter of law, and then address a few supplemental points made by my learned friend. And I stress again the point that I think has emerged already in exchanges with the bench, that this all depends on the claimant, on Brendon being the claimant and having to make out mistake as a constituent part of its cause of action. And in my submission, the analysis in principle hinges on three propositions. First, that because Brendon was asserting that there was a mistake as an essential part of its case, it was subject to a legal burden to prove that mistake. Secondly, that legal burden carries with it an evidential burden. And thirdly, while that evidential burden may shift during the trial, that does not relieve Brendon of the obligation to prove its case on the balance of probabilities. And can I make those propositions good by reference to two authorities? The first is the judgment of Mr. Justice Burrs as he then was in Emmanuel and Avison. That's Bundle 2, Authorities Bundle 2, tab 31, beginning at page 529. And that was a case in which there were two documents which purported to be a loan from the defendants to the claimant, and a charge granting security over the claimant's home in respect of that loan. And one can see that at paragraphs 8 and 9 of the judgment at page 531.
So which paragraph?
Paragraphs 8 and 9, my lord. So Mr. and Mrs. Abbotson are the defendants and Miss Manuel is the claimant.
Mhm.
And then paragraph 13 explains what the claim was. Miss Manuel, who had a frustrated sale, brought the claim for declarations that her signatures were forgeries and not binding on her, and that she was not indebted under the loan. And the judge decided the case on the burden of proof, and one sees that at paragraph 27, page 533. Then Mr. Justice Burse at paragraph 34 set out the issues arising. And little Roman 4 is, where does the burden of proof lie in this case? He addressed that from paragraph 44, first of all reviewing the authorities, and then the passages I rely on are paragraph 54 and 55 of his judgment, where he reaches his decision.
54 and 55.
54 and 55.
Would you like us to read those paragraphs?
I will.
Thank you.
And so what one sees from there that the burden is on the person who asserts something as an essential part of their case, and that is so whether that allegation is an affirmative one or a negative one, as it was in this case. And one also sees in paragraph 55 the discussion of why there's no difficulty with the fact that the burden shifts depending on who's the claimant. That's just the nature of the burden of proof as a rule of law.
You want us to look at 56 and 57 as well?
Not for present purposes, my lord.
He deals there with possible objections to what's in 54 and 55, some of which may
he
arise
does,
here.
but only to reject them.
Yes.
Although he does make the point at the end of 56 that it can be slightly unsatisfactory to decide cases on the burden of proof.
Indeed, my lord, and there's ample authority to that effect. And I should say, that I'll get onto this in due course, this is not a case in which our judge said, I am deciding this on the burden of proof. My point is a rather more subtle one, that the fact-finding exercise he engaged in was one that was only available to him because of the errors he had made earlier on. But I'll come to that in due course.
I think 56 does answer some of the objections to the bright line approach, which he's adopted in 55.
Indeed, my
I
lord.
mean, you could transpose the parties in this case, couldn't you? In 56. Yes. Okay. Right.
Then the second authority, my lord, the second bundle of authorities can go away. The second authorities in the first bundle of authorities have 12, and that's the judgment of the Court of Appeal in the case of Highton and Roby and Hunter. And this is into
Which tab was it?
tab 12, my lord.
Thank you.
I found it difficult when I looked at this case to work out who the claimant was.
There's a statutory provision that deals with that I'm going to show you. Because procedurally it is the frontages, but there's a statutory provision that says you treat it as if it's the local authority, but I'll show your ladyship that. If I could ask the court just to read the head note, see what the case was about. And then can I ask the court to read footnote 1, which sets out the statutory provisions, and in particular in answer to my lady's point, section 8 is set out there, which explains who the parties are to be.
So that's what had happened here. They'd applied. The urban authority had applied, did it?
Precisely, my lord.
Okay, so the effect of section 8 treats the urban authority as if they were proceeding summarily deemed objectors to enforce property.
Indeed, they're effectively they're trying to they're as if they're like the undertaker trying to enforce charges. So the issue in this case was whether or not a highway was maintainable at large. The local authority was in the position of the claimant, and so on orthodox principles, it would have to show that the road in question was not a highway maintainable by the public at large. And the divisional court had said once they showed evidence that no public money had been spent on this road, the onus shifted to the frontages to prove that it was in fact a highway maintainable at large. And that was approach was rejected by the Court of Appeal.
Are you going to show us the passage? Is it Lord Denning?
It's Lord Justice Denning, as he then was.
Forgive
my
me.
lord.
Lord Justice Denning, in which he sets out his reasoning for the second part of the ratio.
I was going to show the passage from page 608, just below the second whole punch, my lord. Which is where he explains the operation of the burden of proof.
The second one. But the Div Court have taken a different view from there.
That one, my lord.
Right. Yes.
So what one takes from that is three propositions, my lord. First of all, that the legal burden is on the authority, notwithstanding the fact that they're seeking to prove a negative. Secondly, that the legal burden requires some evidence to be produced by the local authority. And thirdly, even if the consequence of the production of that initial evidence is to shift the evidential burden, that does not affect the legal burden. The local authority must still prove its case on the balance of probabilities.
If the evidence is so evenly balanced, the court cannot come to a determinate conclusion.
Indeed, my lord, indeed. And I'm going to come on to deal with the suggestion that the judge reached a decision on the balance of probabilities in any event, so my objection is irrelevant. So, my lord, against that, can I go to the judgment to see the judge's approach? And the relevant passage starts at page 62 of the core bundle.
I'm leaving that page open in case we have to come back to it, Lord Justice.
I've put it away, my lord.
Okay,
But,
well, fine. Judgment, which paragraph?
Paragraph 19 is the point of decision, my lord, at page 62. So the judge begins by agreeing that the legal burden of proof is on the claimant. But then he holds that the evidential burden lies on the person asserting it to be public, to establish on the balance of probabilities that it is, and if it does not, it will be found to be private. Now, that in my submission involves two clear errors. First, the automatic imposition of an evidential burden on someone other than the claimant. And secondly, the wrongful treatment of a shift of evidential burden as shifting the requirement to prove a matter on the balance of probabilities.
Sorry, could you just repeat the first of your, sorry, I didn't catch.
First, he wrongly automatically shifted the evidential burden to the claimant to the defendant without requiring any evidence from the claimant.
And the second was a wrongful transfer of the evidential burden, treating it as shifting the requirement to show.
Indeed, my lady.
You said, I think, wrongful treatment
The wrongful treatment.
of a shift.
Even if the evidential burden shifts, as the passage I've just shown you from Lord Justice Denning makes clear, the claimant is still subject to the obligation to prove on the balance of probabilities. Whereas
It's certainly the case that Lord Justice Denning's, the passage in that decision does not, when it talks about a shifting evidential burden, it doesn't talk about the balance of probabilities test ever shifting.
well, in fact, if we can turn the passage up again, my lady.
That's why I left it open. I had a feeling we might have to come back to it. Yeah.
Because Lord Justice Denning goes further than that in my submission, my lady. It's page 185 of the bundle, 609 of the judgment.
For my part, I read on halfway down that page. I think my lady did as well. Was that?
It's by the
First whole punch.
first whole
Yeah.
page, precisely.
It's a provisional burden.
Yeah, that, however, is not a legal burden, but only a provisional burden, a burden raised by the state of the evidence from which the court may draw an inference one way or the other, but it is not bound to do so.
Right.
Is the phrase "a provisional burden raised by the state of the evidence" the same thing as an evidential burden?
Well, the phrase evidential burden is a phrase, I think it is, sorry, it's the
Yeah.
answer to your lordship's question. It's a phrase which is used with a variety of different meanings, I think, in the authorities. The core of the idea is that the state of the evidence at some point may be such that the court is prima facie persuaded of the other party's case, and therefore, in practical terms, you've got to produce evidence if you want to rebut that.
The phrase "evidential burden" isn't used in this judgment, is it, by Lord Justice Denning?
It's not, I think. And he talks, just above the second whole punch, he talks about a provisional burden raised by the state of the evidence.
Yes.
It's certainly been discussed in those terms with the label evidential burden.
It has, my lady, yes.
So it's just you would say it's just evidential burden is a modern way of putting the same point.
The same point. And I hadn't been intending to refer to it, but it may be in light of the interventions just now. It's worth looking at paragraph 70 of the judgment of Mr. Justice Gross, as he then was in the Equitas case, which is page 360. So the same bundle behind tab 22.
Okay. All right. I'm going to put a post-it in more Denny. And then go back to what, 360, right, whereabouts in his judgment?
Paragraph 70. And he simply makes the point that one can overcomplicate the terminology and then explains it more simply in terms that if the party with the legal burden produces some evidence, it might be right to talk about an evidential burden.
Have you got Phipson, a relevant passage from Phipson on this point in the bundle?
We do have them in the bundle, my lord.
You weren't going to refer to it?
No, I was endeavoured to go to the authorities themselves rather than to the textbook. And what one, it's, so I've got the wrong bundle out. It's at the very back of authorities.
Can I just ask you to, sorry, at the risk of irritating people, can I just ask you, you said that there were two errors in paragraph 19. The first one being that the judge started automatically from the proposition that the evidential burden was
On someone other than the claimant was exactly how he put it. I.e.,
Defendants.
defendants. Yeah.
yeah. And then the second error?
I got as far as wrongful treatment of, and then
So the judge, when having found that the evidential burden shifted, he said that that carried with it an obligation to prove on the balance of probabilities. And that in my submission is wrong because, as Lord Justice Denning explains, the burden of proving on the balance of probabilities always remains on the claimant.
Yeah, okay. I mean, it's sort of part and parcel of the same confusion between legal and evidential burden.
In fact, part of the confusion here perhaps is that the way that the judge has approached it, there is no distinction. The approach of the judge is effectively to put the legal burden on my clients and effectively to create a presumption that the sewer is private.
yes.
Okay, well, we'll come on to the detail of this in a minute, but if you say that the legal burden is on the person alleging a mistake, which you do, and you say it's inherent that they have to then prove, they have the legal burden to prove that the charge was erroneous, which means that they have the burden to prove that the sewer was not public.
Indeed, my lord, otherwise there's no mistake.
Right. If they then produce a piece of evidence that suggests, if not countered, that the sewer was not a public sewer, that shifts the burden to you to demonstrate by evidence to the contrary. That's the way the evidential burden shifts.
Indeed, but it doesn't mean that I now must prove something on the balance of probabilities. That's precisely
that's
the
legal. That's the legal burden.
Indeed.
But the actual analysis is that if they produce a piece of evidence that, if not countered, would satisfy the judge on the balance of probability, then in a sense the burden of producing evidence shifts to you to knock the pointer back, as it were, but beyond the 50% mark, if I can put it that way.
Indeed, my lord, but that as Lord Justice Denning's exposition shows, is really, it's more a pragmatic question of the state of
Yeah,
evidence.
it's
rather
just
than
how the when people talk about evidential burden, it's actually a sort of, it's something of a misnomer. It's really just, as it were,
Yeah.
Say perhaps in this sense, and maybe here it would be useful to go to Phipson, in fact, to
Well,
take up
yes, so
my-
this-
It is quite helpful
Um,
section.
yeah,
Tab
to take up my-
38
Yeah.
my lordship's
it
invitation.
introduces this thing called the persuasive evidential burden. Is that editorialising on Phipps's part, or is it is it used in the authorities, that
So
phrase?
he's using persuasive burden as legal burden.
Exactly. This is using it as my lady
Yes.
says with the
Yeah.
legal burden, then evidential burden, which is used in the second paragraph.
Yes.
Of Phipson, is used in the sense of a duty on the person who owes the legal burden to pass the judge to show enough evidence to get off the ground.
Okay, but persuasive, is that a word used in the authorities, or is that the editors?
That I think is the editors.
Okay.
So he describes the evidential burden as the burden of producing evidence, not a
Yes.
burden of showing something on a balance of
Yes, a
evidence.
duty of passing the judge, or burden of producing evidence.
And it's a point which is probably of more materiality in criminal cases if you had a question of no case to answer at half time.
And then you rely on the short single sentence third paragraph.
That they're on the same party, but that's nothing more in my submission than the point that Lord Justice Stenning makes.
Well, that's the starting point, though. The evidential burden may shift, may move.
And the next paragraph again makes the point that it's wrong to speak of the persuasive, which we've seen means the legal burden shifting during the course of the trial. So it's to the same effect as of what Lord Justice Stenning has said.
Right.
So those are the two errors that I say that the judge made in principle. And his reasoning to those errors in my submission doesn't support the departure from principle. The core of the reasoning is paragraph 16, so that's back one page from where we had open, where the judge looks at section 219 and concludes from that if all private sewers, if all sewers are private sewers unless they are public sewers, the burden of showing that any particular sewer is public rather than private must fall upon the person asserting that it is public. A person asserting that a sewer is private or denying that it is public is not mounting a positive case, since all sewers are private unless they are public. And I say that that's wrong for at least two reasons. First of all, it's premised on the idea that the burden of proof is on a party asserting a positive case, when, as you've seen both from Emmanuel and Avison and from the Heighton and with Roby case, that's just wrong. If a negative allegation is an essential part of your case, the burden is on you anyway. But secondly, in my submission, it simply places too much weight on section 209.
Well, I mean, so yes, he was relying on the statute, isn't he?
Indeed, that's where he got this distinction.
If he was right to rely on the statute, if the statute says all sewers are private unless they are public, does that create a presumption which puts the burden in a different place?
Well, if the statute said that, we have to look at the provision to see whether or not it was a provision intended by Parliament to cover civil proceedings. But in my submission, it is simply a stretch far too far to say that that's what section 219 is about.
So the proposition in that sense is right. If all sewers are private unless they are public.
Well, it's right, but the converse proposition is true. All sewers are public unless they are private. All the statute does is set up two categories of sewers. It says there are some sewers that are public, and here are their characteristics, and then everything else is a private sewer. That's all that the statute does. It's not seeking to affect the...
so the default position is it's a private sewer.
Well, not necessarily, my lord, because in the case of a sewer constructed by an undertaker, that's never been a private sewer. That's a public sewer from the moment it's constructed. And to talk about default, if anything, in my submission begs the question. That there is no default position.
It's an either or.
It's an either or, exactly.
So you say you say it depends on the purpose for which you're asking the question, essentially.
Indeed, my lord.
Well,
Yes,
another way of putting this is that section 219 is a definition section. Did Parliament intend a definition section of that kind to have the sort of consequence that the judge appears to have treated it as having? That may be one way.
Indeed, my lady. I think that was the way I meant to put it earlier. In fact, respectfully, that is the question. Can that much be read into section 219? And in my submission, it's clear it can't. It is simply a definition section seeking to tell us what the words in the statute mean, and for that purpose, creating two categories of sewers with different rights and obligations attached to them.
So just turning up 219 again. That's at the back of tab 8, isn't it?
Yes, my lord.
And you took us to drain, to sewer, to public sewer.
Yes, my lord.
So
What's the definition of private sewer, insofar as there is one, is just at the end of the definition of public sewer.
So he was saying that because that, this is what he was saying, that because that's how it's expressed, he was saying that a private sewer is something which isn't a public sewer. Is that right? There is no other, as many points out, that is what private sewer means, there's nothing else. It's something which isn't a public sewer.
Exactly, for the purposes of this Act. The Act simply creates two categories of sewer. I say creates two categories, so it defines two categories of sewer for the purposes of attaching rights and obligations to one in particular.
So you just say it depends on the purposes. If you're trying to justify a charge, you would have to show that this was a public sewer.
Indeed.
And you're saying if they want to recover money, they've got to show
That it's not.
It's not a public sewer.
Indeed, my lord. And just to say again, when it comes, of course, to how you weigh the evidence that is presented in the burden, the fact that I'm an undertaker and all the other considerations that your lordship has mentioned,
Yeah, we've only spoken about legal
would be highly
burden.
relevant.
I mean, we're talking about legal burden there.
Precisely.
So you say that it's in fact, going back to paragraph 16, I know you were at the time, paragraph 16, the mistake is, you say, between line 3 and 4 of page 62. Yes, a public sewer is a sewer which is not, a private sewer is a sewer which is not a public sewer, yes. But that does not the same thing as saying all sewers are private sewers unless they are public sewers.
Yes,
in the way
yes,
that the
my
judge understands that.
Well,
Right.
certainly in terms of him showing that it's public.
Yes, if all sewers are private sewers and they're public sewers, when the judge then says the burden of showing that any particular sewer is public, I say that logically does not follow.
Well, okay.
Well, yeah, I mean, it's not wrong to say the burden of showing that a sewer is public must fall upon the person asserting that it's public. If I put it that way, that's not wrong.
That bit would be correct, indeed, my lord. That bit would be correct.
Yeah.
But that would cover the case in which I was sued as the undertaker.
But he's expressing it, he's using that phrase, the unless phrase, to create a sort of presumption, isn't he?
That's precisely.
Whereas you would accept the unless phrase as just if it was just a paraphrase of the either or, in which you say is the way it's expressed in the definition section, i.e. 219.
I would, yes, my lord.
Okay, right. Thank you.
The other point made by the judge is paragraph 21 is to say that whether a sewer is a public sewer depends who owns it and in what capacity. It's a matter of where title is. Again, in my submission, that's nothing to the point. The fact that it is a matter of where title lies, the fact of that doesn't affect ordinary principles as to the incidence of burden of proof. Can I then deal very quickly with points taken in my learned friend's skeleton? And perhaps if I can just give headline answers and come back and reply to the extent necessary given time. I think it's fair to divide the points that my learned friend makes into four. The first is that my learned friend supports the judge's conclusion that the statute provides that a sewer is private unless it's public. I think the court has my submissions on that. Secondly, my learned friend makes various points to assert that there is a burden on a party who asserts a positive case, but not on a party who asserts a negative case. Again, I think the court has my submissions on that. Thirdly, my learned friend relies on at least two cases to support the notion that it is relevant to the instance of burden of proof to consider the parties' respective knowledge, their responsibilities and so forth. And if I can give as I say, the headline response to that, the first case is the House of Lords decision in Nemo and Alexander Cowan. When your lordships see that case, that was a case about a statutory cause of action. And when you have a statutory cause of action and the statute mentions a particular matter, an issue arises as to whether the matter mentioned in the statute is a constituent part of the cause of action and hence on the claimant to prove, or whether Parliament intended it to operate as a defence and hence for the defendant to prove. And so in that context, when you are construing the intention of Parliament, it is of course relevant to have regard to the parties' spheres of responsibility, their respective knowledge, because Parliament would no doubt regard that as relevant to where it wants to put the burden of proof. But that, in my submission, is of no assistance here, where the cause of action is not statutory. The cause of action is a common law claim in restitution, and there is no doubt what the constituent parts of that cause of action are. The other case that my learned friend relies on is another House of Lords decision, Joseph Constantine and Imperial Smelting. It's a similar point, but in a slightly different context. That was a case about whether when someone says that a contract has been frustrated, they must show that it was frustrated for reasons other than their default, or whether it's on the party seeking to enforce the contract to defeat the defence of frustration on the basis that it was caused by the fault of the defending party. That again that again is a case about the constituent elements of the defence of frustration.
All right, thank you.
It's of no assistance here.
So those are your headline points.
Those are my headline points, and
We'll
to
see
the
what
extent
happens.
necessary in reply,
Yes.
I can develop them. Fourth category of point my learned friends make is the general point: the divine right undertakers can charge with impunity, and poor householders are left having to prove
Floodgates.
floodgates. And
I'm trying to avoid that sort of pun. Okay. Anyway, but your point is that it would be his that it would be have consequences generally.
indeed,
you say is
I say simply wrong, because if I sue for charges, then the burden is on me. And similarly, as I've indicated, of course, the fact that I'm an undertaker will be something that the court will have regard to in its assessment of the evidence in whatever way is appropriate on the facts of the case. But that's no reason to adopt a position as to the burden, which is wrong in principle. Can I then turn to the second point that I make under ground one, which is whether or not the judge's approach is vitiated by this error. And if I may approach it in this way, first I'll deal with how I say the judge should have approached his fact-finding exercise on the basis of what I say about the law, and then I'm going to contrast that with what the judge actually did. And the question for the judge here was whether this sewer was, if you like, a public asset or a private asset, in the sense I explained at the outset. And the task in my submission for the judge was to weigh all the evidence without presumption to establish whether or not it was more likely that this was a private asset. And undertaking that task in my submission would have required him to weigh in the balance the following facts, and I'll come on to
Is the actual question is whether it was not a public asset?
well, if it's not a public asset, then
Whether it was a public or a private asset, isn't that?
well, no, to decide whether it was a private asset, because ultimately the burden is on the claimant to show that it was a private asset.
Well,
I suppose the difference in our formulation only matters on the burden.
Wasn't the burden on the claimant to show that it was not a public asset?
Not a public asset, or which means the same thing, that it's a private asset.
Okay.
But yes, your lordship's formulation is technically speaking more accurate than mine.
Yeah.
Well, yeah.
If it wasn't a public asset, you weren't entitled to charge.
We weren't, no, my lord.
That's the actual question, I think.
Indeed. And the judge would have had to have weighed in the balance the following facts. On the evidence, this was a large sewer. It served multiple properties in different ownerships. And it didn't appear to have a system of private rights.
Large. Say again.
Large. Served multiple properties in different ownerships. And did not, on the evidence before the judge, appear to have a system of private rights and obligations governing its maintenance and use. And the judge therefore had to ask himself, does this situation, or what is the probability of a private landowner constructing an asset like that for private purposes and being so casual in terms of the rights governing its use? As against the chances that this situation, multiple users discharging apparently as of right, in fact reflected the fact that it was a public sewer. Now, if my clients had been able to plead and prove a case factually,
Is that the only evidence that you say there was?
that's where we were at trial. I mean, the evidence on both sides, I think one has to admit, was pretty.
You're probably going to guess what I'm about to put to you. It matters not, you say, that the records that your clients are obliged to maintain do not show that this is a public sewer.
That was clearly a matter that the judge was entitled and indeed obliged to weigh in the balance. I don't shrink from that, my lord. And yes, you'll.
Doesn't that? I mean, if we're talking about burdens, would the claimant not be entitled to say to start with, that would shift the evidential burden to you, and then you can rely on these sort of points. But at least, would you not start from the proposition that you're obliged to maintain a map showing your public sewers, and if it's not on it, it's not public? As a matter of evidence.
Purely as a matter of evidence, my lord.
I understand the legal burden hasn't shifted, but as a matter of evidence.
The difficulty is attaching the kind of significance to any shift like that the judge seemed to. Plainly, the fact that it was not shown on the map was a matter that weighed in the claimant's favour, and it's a matter which required explanation and countering evidence from my clients. I'd accept it to that extent. Now, if my clients could plead and prove a case as to how the sewer came to be vested, so a factual case as to what happened to vest this sewer here. We built it in 2004, we declared it to be adopted in 2002, something like that. That would clearly be determinative of the case in my favour, had we been able to do that. But the converse in my submission doesn't follow. That just because we are unable to plead and prove a case as to how the sewer came to be vested, the judge was not excused from the task of considering whether, in light of the evidence as a whole, it was more likely than not that this sewer was not public. So if you
Well, that's, without talking about evidential burdens, that is what Lord Denning was proposing, wasn't it? He was proposing that the court looks at the state of the evidence, and it's only the question of burden
only comes in
if it's evenly balanced. And you say that's what should have happened here. The judge should have looked at all the evidence, including the record or absence of records, but the totality of the evidence pointed clearly in one way.
The point I'm coming on to make, my lord, which I hope will answer your lordship's point, is that there were effectively two questions for the judge, which he melded into one, but I had put two questions to him in closing. There's the first question, whether when you look at the various factors that I mentioned that my lordship expanded upon with the sewer maps, whether you look at those, whether it is more likely or not that the sewer is not public. And then the question of whether or not there was a factual case available to me on the pleadings, which I could prove on the evidence, as to how the sewer came to be vested. And the judge, as I hope to show shortly, melded the two, and he lost sight of the difference. And that, I don't independently criticise, that was a direct consequence of his error on the burden of proof. But had the case that I might, had I been able to plead and prove a case as to how the sewer came to be vested in me, that would have been sufficient to win the case for me, but it wasn't necessary for me to win the case.
What it is probably necessary, or at least evidentially relevant, is as part of the picture, you need to show, you may need to persuade a judge as to why you may not be able to show how the thing vested. One explanation might relate to the position of the local authority at the time.
Absolutely, my lady, and that would obviously be very nuanced depending on the facts. So if it's a very old sewer, probably less significance would be placed on the failure to provide an explanation than if it was a more recent sewer. But all of these questions could play out in whatever way is appropriate on the particular facts of the case. But that wasn't in my submission the task that the judge undertook. We can see what he did from paragraph 87 of the judgment. And that's page 98 of the court bundle. And here what the judge does in my submission is, as I say, amalgamate the two quite separate issues that I've talked about. One is a question of the assessment of the factors tending to indicate that this was not a private asset. And the other is the question of whether or not I was entitled to run and could prove a case as to how it came to vest.
Sorry, could we just, sorry, I'm not sure quite what you're doing at the moment. You took it, you said we should go to 87, which deals with how the judge, should we not start with your pleaded case?
The reason I'm doing it this way, my lord, is I'm not going to make a criticism of the judge's approach to the pleading on the basis on which he approached my case. What I'm going to say is that he was wrong to dive into my pleaded case as opposed to considering the claimant's case.
So with 87, what in particular did you draw to our attention?
Well, what the judge does here is he fails to distinguish between the two tasks I've mentioned. The first is assessing all the evidence to see whether or not it is more likely or not that this was private, and the second is whether or not I can plead and prove a case as to how it came to vest. And then at 88 he says, I do not consider that this argument was available to the defendant since the primary facts and the inferences to be drawn from them were not pleaded. Well, I think if he's right about the burden of proof, I have to accept that that was the appropriate course, because if he's right that it's on me to prove these facts, then there we are.
Well, I mean, the burden, the legal burden is, you say, not on you, sorry, on the claimants, Brendon, and if you're going to rebut it, you have to produce some evidence. If they have started with something which puts an evidential burden on you, you've got to then actually plead some facts. Don't you?
My lord, no. In my respect, that's wrong, and that's committing the error that the divisional court committed in Heighton and Ruby, because the sort of informal shift of the evidential burden doesn't put any onus on me. The court must still consider all the evidence properly available.
But you're not generally entitled to produce evidence of facts which you haven't pleaded.
But, my lord, that maybe brings me on to 89, where the judge said it was not in dispute that the sewer was located on land owned by the council, was a large sewer, served multiple properties on the estate and discharged into a watercourse. Now, those are the first of the factors that I mentioned earlier. The judge recorded they were not in dispute. There could not have been a sensible pleading objection to me relying on that.
Yes.
The second, or the only issue that I mentioned earlier that's not mentioned there is the question of what private rights there are. Could I just ask that we turn up the supplemental bundle? Because again, that will demonstrate why there's no sensible pleading objection to me relying on that. There was in fact a judicial determination about the extent to which this issue arose at the CCMC. It's tab 26 of the supplemental bundle. Order of Deputy District Judge Hassel, and over the page at paragraph 7.
We got this quite late, I think.
We did. It's mentioned in my scheduled argument, but I'm afraid it had slipped through the net on preparing the bundle. And the judge, at paragraph 7, the judge orders that a revised DRD be provided, including the issue, if the sewer is private, what right does Brendon have to discharge into it? So the question of what private rights there were in play had been identified as an issue requiring factual investigation at the stage of case management. So again, there could be no sensible pleading objection to me relying on that.
Wait a minute. It had been identified as an issue for disclosure.
Indeed.
That's not the same.
It's not. Well, unless one were to suggest the issues for disclosure are meant to identify the issues requiring disclosure that arise on the pleadings. And it doesn't mean that it was expressly pleaded. I have to accept that, my lord. But what it surely means is that there can be no sensible claim that anyone is taken by surprise.
Doesn't have to be pleaded. The absence of a reference to pleading is not an answer.
Yeah, there's no unfairness.
So the assertion that you couldn't rely on the point in 88 was wrong.
Indeed, my lord.
The judge considers that, you say, erroneously considers
And
the
I'm-
private or right position.
I'm going to come on to that paragraph because in my submission that is an extremely important paragraph and it is unfortunately replete with error. Can I
So we got
return to paragraph 89?
yes.
So the judge there, he sets out some of the factors I've mentioned, but what he doesn't do, at least at this stage, is seek to consider their significance in terms of the balance of probabilities. At this stage, what the judge appears to do is use them as stepping stones in my factual argument as to how the sewer may have become vested. So he's addressing them to the second stage, can the defendant show it became vested, but not considering their significance for the first question of is it likely that this sewer is private?
What is the argument? He's in 88, this argument, what is he saying there?
So this argument, in my submission, what he's saying there is the argument I attempted to mount at trial, which was to say, well, when you look at all of this, it appears likely that the local authority must have built this in its capacity as delegate for the undertaker.
Is the vesting point part of that or not?
Well, that would have been, had that case been open to me and proven, that would have meant that I had proven facts which constituted a vesting, and I would have won.
So that's not okay, right? Yeah.
But that's all that the judge is considering. He's not considering the prior question of, having regard to all the evidence, is it likely that this sewer is in fact private?
Okay.
Paragraph 90 to 92, the judge considers whether or not the local authority constructed the sewer.
Sorry, I mean, just quite a lot of the points, I mean, I understand you say that 89 was not disputed, but there's quite a few of the points which you earlier made, which you say the judge should have weighed and asked himself, are included in 87 as matters which were in your skeleton argument, but which the judge says you're not entitled to run since you hadn't actually pleaded the primary facts.
Well,
I mean, that you've got to grapple with that, haven't you?
but that's my point, my lord, that paragraph 87 doesn't distinguish between the two things that I was very careful in my oral closing to distinguish between the judge, which is the question whether or not it is likely that this was a private sewer, generally. And then the second question, whether or not I can plead and prove a positive factual case as to how it could vest. And as I said, success on the second issue was sufficient for my purposes, but it wasn't necessary.
Right, but on the first of those, isn't that what he's addressing in 87?
Well, the 87 melds the two, but when one comes on to the detail of his reasoning in the paragraphs that follow, my lord, in my submission it's clear as only addressing the second, and indeed I would add this, on the judge's approach, that is the correct approach to take, because the judge has subjected me to the burden of proof. So it is therefore unsurprising that he is looking for facts that I have proved to see if I can overcome the burden of proof. But if one looks at the detail of his reasoning from paragraph 88, as I said, in my submission it's clear that he's engaged in the second of that exercise, and that's particularly clear in 89. If it is engaged in the first exercise, when he mentions those facts, he has to consider their significance for the likelihood of the sewer being private. There's no discussion whatsoever of that, and that in my submission is consistent with the judge treating those matters not as important matters in the weighing of the balance of probabilities, but as a stepping stone in my argument on the second point. Then paragraphs 90 to 92 deal with the question of whether or not the local authority constructed the sewer. So that is very clearly my argument on the second point. And the judge concludes at paragraph 90 that the sewer was likely constructed with the roads. And then at 92, at the very end of 92, page 101, he says that he cannot accept that the state roads in the sewer in question were constructed by or at the behest of the local authority. The defendant's argument falls down at this point, therefore. And that clearly was the decision on the burden of proof. And I say that because if one goes to 95, which I'll deal with in more detail later, but if one goes to 95, he says that it seems to him that an adoptable sewer might well be built by a local authority. So 92 could not be read as an affirmative finding that the local authority did not build the road. Build the sewer, sorry. 93, again, he deals with the capacity in which the local authority constructed the road. Again, that's only relevant to my argument on the second point. It's not relevant to the prior question, the first point as to the overall probabilities. And then 94, and this is the point that my Lady Justice Falk mentioned. This is a lengthy paragraph dealing with the key question of private rights. And the judge in my submission...
Should we read 94? Are you going to make a number of submissions about 94?
I am, yes.
Would it be a good idea if we just refreshed our memory of it?
My lord.
Should we just read it again? And leads to his conclusion at the first sentence of 94.
which crucially leaves out the question of private rights.
Okay, so now what do you want to say about 94?
94, in my submission, he does two things. First of all, he says that the absence of evidence of such a scheme is not a sufficient basis for the inference that the sewer is public. And I say two things about that. First, I say that that is language redolent of applying a presumption that the sewer is private unless proved otherwise. But secondly, in my submission, the judge doesn't take into account the fact that even though it may not on its own be a sufficient basis, it is an important factor to weigh in the mix. And we'll come on to that in paragraph 95. But the reason maybe that the judge is able to avoid that is because of the second thing which he does, which is effectively to express doubt as to whether or not it's right that there was not a scheme of private rights, and to apply that doubt to my detriment. And there are,
Where precisely do you say he does that?
well, he does that at the end of the paragraph, the penultimate
The mere-
sentence.
The possibility.
The possibility undermines the defendant's arguments at this final stage too, and that presumably is why, when he comes to what assessment he does in 95, he makes no reference to private rights. That would be
The argument being there may be any number of reasons why.
No, it's the sentence before that. The
Yes.
final sentence is dealing with the fact that the local authority, we had someone from the local authority coming along and saying it's not our sewer, not our problem, and the judge is disposing of the significance of that in the final sentence. So that's not to do with private rights.
Okay.
It's the sentence before that when he says that the possibility that there may be private rights undermines the defendant's arguments. He therefore appears to be resolving such doubt as exists against me, and that then allows him in paragraph 95 to have no reference whatsoever to private rights.
But is he saying that the private rights arguments here don't get me anywhere at all?
That appears to be what he's saying.
Why wasn't he open for him to say that on the evidence?
Let me deal with that. There are two problems with his approach. The first is, insofar as there were doubts, it wasn't appropriate to hold those against the defendants. And I say that for three reasons.
Right.
First, we get back to the burden point. On the judge's approach, it's entirely logical to say, well, that's the defendant's problem, because the burden is on them. Had he decided the burden issue correctly, he could not have adopted that approach. Secondly, when it comes to weighing the absence of such, of evidence of such rights in the mix, documents evidencing those rights are quintessentially something you would expect the claimant to have. The claimant was the original purchaser of this property from the local authority. If there is a document where the local authority grants a right of an easement of drainage to the claimant, that is a document that is, at least has been in the claimant's possession.
Sorry, is it clear on the evidence that the claimant purchased it
Yes.
from the local authority?
That was the claimant's own evidence. I can show your ladyship that if you're lady.
No, fine, as long as it's clear.
And thirdly, as you've seen in the CCMC order, that was an issue that was identified as something that...
Sorry, on the point about, you say that the claimant should have had the documents showing purchase from local authority. I mean, local authority should have documents showing sale to claimants.
The local authority wasn't a party to these proceedings, my lord. If one's asking which party to these proceedings should the absence of evidence of private rights weigh against, in my submission it must be relevant to that,
Right.
that the claimant could have bought any document showing such rights.
Okay, but I thought you said the local authority produced somebody who came and gave evidence.
They
but
did.
Without documents.
He certainly didn't bring along any documents evidencing the position as to private rights.
But, I mean, the disclosure obligations would be on the claimant and defendant.
Yeah, no, I understand that the local authority wasn't a party, but it's a bit odd to have somebody coming along from the local authority to give evidence without referring to any documents.
I'm at risk. There are
Okay.
local authorities are not always the easiest people to get documents out of, if I can put it like that.
No, but it's more that somebody comes and sort of, in a case like this, somebody comes and gives evidence from the local authority without any sort of documentary basis for it. I mean, local authorities operate on the basis of documents.
Well,
Who called the person?
we called them, but that was a point that my learned friend took of the judge places reliance on the absence of documents generally from the local authority, tending to show their construction of the sewer. So that
But is this just, I mean, I'm not sure quite where this point goes. I mean, you're saying that some weight should have been placed upon the fact that the claimant didn't produce documents.
I'm not going that far for present purposes. That's what I would say at any retrial. What I'm saying for present purposes is that the judge was wrong to resolve that doubt against me, and that flowed from his error on the law on burden of proof.
Right, but that was your first point.
Yeah.
Indeed. And then my second point is that the judge's reasoning. Sorry, my lord. It was my first point in support of my first point as to why the judge was wrong in here. My second point as to why the judge is wrong is that the judge's reasoning that there was doubt is, in any event, in my submission, problematic. He talks about a scheme of development which granted relevant private rights.
So where are we now?
This is still in paragraph 94. With respect to the judge, that's not an easy concept to follow. There's no concept of a scheme of development granting private law rights, private law easement rights. Schemes of developments are things that arise in the context of restrictive
But
covenants.
this is his evaluation of the evidence, isn't it?
It is, my lord.
And this is a judge who's pretty familiar with conveyancing and property. I mean, sorry, I'm struggling to understand quite what the sort of basis on which you're asking us to look at this evidence or evaluate or interfere with his evaluation of the evidence.
Well, my lord, particularly in light of time, let me not spend too long on this. Let me try and keep the first point I made in the court's mind. The key error for present purposes is that the judge resolved the doubt against me, such doubt as there was against me. Had he not found as he did on the burden of proof and approached this question without presumption, when he came on in paragraph 95 to make such assessments as he did, he would have had to have had regard to the evidence
I
of
know
private
you're-
rights and engaged in the kind of debate that your lordship and I.
I know you're concerned about the time, but for my part, I think you've got to still make good your argument that he did decide it on the burden of proof. He made comments about the burden of proof, which you've sought to demonstrate were wrong. But is that how he ultimately decided the case? On one reading of the judgment, he adopted the Denning approach. He looked at the evidence, found the evidence went one way or went a certain direction, and didn't have to resolve it on the burden. Can you point to something specifically which shows that he did in fact decide on the burden of proof against you wrongly?
My lord, that's why I said earlier that I do not say that in terms he decided on the burden of proof. What I say is that the exercise he engaged in that got him to paragraph 95, where he comes closest, was one that was flawed as a result of his concentration on the burden of proof. And that's why the point I've just made about his approach to private law rights is so important. Because when one gets to paragraph 95, the only matters that he weighs are size, quality, and multi-property
So
connection.
really, you're saying this is a case where he omitted material parts of the evidence in his analysis.
That's right, my lord, but I say that follows from his error on the burden of proof. That's why the error on the burden of proof vitiated it.
Right. Thank you. Now, how are we doing? What more have we got on ground one?
I'm a bit behind.
Right.
Unless I can assist any further on this point, what I propose to do is to leave the points about Mr. Griffith's evidence to my skeleton. I've set out what I say the true position is there, and move on to ground two.
We need to hear about it.
I think we need to hear you on ground two as a priority. Let's come back to Mr. Griffiths as and when we need to.
I'm grateful. If I can then move on to ground two and deal first with the legal principles. I can take that shortly as it is, I think, common ground. And while we're in the judgment, we can see how the judge put it at page 115, page 122. 112, paragraph 115. So the judge explains that under section 32, limitation doesn't begin to run until the claimant either has discovered the mistake or could with reasonable diligence have discovered it. And as he says, the burden is on the claimant to show that it could not have discovered the mistake without exceptional measures which it could not reasonably have been expected to take. And the concept of reasonable diligence involves two considerations. First, was the claimant put on inquiry, or second, whether, having been put on inquiry, they acted sufficiently diligently to ascertain the existence of that mistake. If I can quickly amplify that by reference to two passages, one a quotation from Paragon, and
Just to be clear, do you say that any of that is wrong?
No, I endorse that entirely, my lord.
But you're just amplifying by reference to Paragon. Where is that in the authorities?
If one goes to, well, I'm going to go it's not, Paragon is not in the bundle, but there's the relevant quotation is in the OT Computers case, which is volume 2, tab 33.
This is Lord Justice Mayles.
It is indeed, my lord. And at paragraph 31, he quotes from Paragon, and your lordship will recognise it as a more extended quote of the passage the judge relied on. And the passage to draw to your lordship's attention is the first sentence of the quotation, where it says, "The question is not whether the plaintiffs should have discovered the fraud sooner, but whether they could, with reasonable diligence, have done so." So that's the
test, you say?
That's the test. Could, not should. And the second passage to look at, my lord, is paragraph 47, page 589. And if I can ask the court to read that, but the point that you get from that is that at all stages it's a question of reasonableness.
In the bottom, 589, sorry. Paragraph
47.
Yeah, and paragraph 48.
So, and paragraph 48, my lord. But
Objective.
It's an objective test. So, well, the judge has talked about the claimant being put on notice. The claimant doesn't actually have to be subjectively on notice. They have to be on notice as if they're a reasonably attentive person. So that's the test. If I can then turn to the evidence and look at three matters in particular. First, in the supplemental bundle, page 93.
Behind tab 13, isn't it?
Tab 13, my lord. So this, what happened was that in 2003, I think it was, the claimant had sold part of its land to a third party, and then in 2009 it repurchased it. And this is part of the conveyancing material on that repurchase.
Yes.
And this is one of the, it's a standard conveyancing search.
Yes.
Question 1.2 asks, does foul drainage from the property drain to a public sewer? There are no public sewers shown on the public sewer maps that serve the property. And 1.3, does surface water, what we're concerned with here, drain to a public sewer? Answer, there are no public sewers shown on the public sewer maps. And then, crucially, for present purposes, over the page, question 4.1, what is the basis for charging for water supply and sewerage at this property? So the very question about which the mistake was said to have, the very question the mistake was said to have concerned.
Yeah.
Answer, no definitive answer. Please refer to vendor or pre-contract documentation. So the issue was addressed as part of conveyancing search.
So let me just get this right. This is a report. Sorry, it's sent by who to who? Just
This is a report produced by, I think, Personal Search Agency, so one of these search companies that they're acting conveyancing, and sent to Stevenson solicitors, who are the solicitors acting for Brendon on the purchase. And just while that's open, I should show the court page 95, which shows the land being repurchased.
Sorry, but just to also be clear, the questions and the answer, who are the questions posed by Brendon's solicitors?
I don't,
That's the way it seems to be. It looks like it's a question. The answer is provided by the personal search agency to a question presumably asked by the solicitors.
yes, my lord, I wouldn't want to place too much emphasis on the solicitors asking the question. There's no evidence about this, but these are normally just standard conveyancing inquiries. So I wouldn't want to suggest that someone at the solicitors has sat down and thought we better ask that question. It's simply a question that gets asked. As a
Your
matter
point
of
is,
simple-
in the process of acquiring the property, there is a written question to which there is a written answer.
Indeed, my lord.
Yeah.
And the answer is needs more investigation. Don't know.
Yes, but so the reason I asked it is that if Brendon's solicitor had, as it were, turned their mind to this question and asked it of the search agency and got that answer, that's perhaps a different situation to where the claimant's Brendon's solicitor just simply, as it were, picks a standard form off the shelf and sends it off and gets these answers back.
That would certainly be a stronger situation. I suppose, actually, my lord,
There's
having
just
said I
no-
don't want to place emphasis on it, here again the burden may be relevant because, as you've seen, the burden is on the claimant. And if the claimant wanted to say, well, this is the second case rather than the first case, it was for the claimant to reduce evidence showing that.
But there was no evidence particularly about how this document came into being or anything like that.
I mean, these look fairly standard questions,
They do. and
but in all conveyancing, there are standard questions, aren't there?
there are. And
Commonly asked, and then supplemental questions. And
a
your
dra-
point is nothing turns on that, is it?
Indeed, my lord. I mean, a drainage search is in fact a standard requirement of all mortgage lenders. So there would be very, very few conveyances in which something like this is not done.
So you're about to show us the
I was about to show you that the land being repurchased is at 95 in black, and so it's directly next door to the rest of the site. The rest of the site is in the castle to the left. And the reason I show that is that in my submission, it's clear that anything you say, which should be clear to a reasonable person, that anything you say about drainage affecting that parcel is at least likely or possibly going to affect drainage of the retained land.
I mean, if you look at the following off of it, there's a couple of pages of guidance, or one page of guidance.
There is
Notes and guidance.
and
That looks pretty standard form as well, isn't it?
note 1.3 says in terms, in some cases the water board's records do not distinguish between foul and surface water connections to the public sewerage system. If on inspection the buyer finds that the property is not connected to surface water drainage, the property may be eligible for a rebate for surface water drainage.
But again, I mean,
That's
it's standard form, but you say, so what? It's part of the information, your
But-
case is, that was before the purchasers.
I say a bit more than so what, my lord. I say the
Sure, you
fact,
would put it as elegant as
so
that.
wait a minute. So I'm not keeping up with this. This is a copy at 95. This is a copy of the local authority map.
with this, I'm not sure again there was any evidence of what produced
Well, it
this
is, of course.
copy. And when these
Question
search companies
3.1, we have viewed the public water main map for the property and on your behalf and provide our answers, a copy extract is provided.
sorry, yes, your lordship is correct. I
And
apologise.
questions 3.2 to 3.4, the answers are based on that.
Yes.
Now, I appreciate that talking with, is that mains water? Or, because they don't say that 4.1 is based on it. Is it the same map, or is it a different map, or what? Just don't quite get it. Oh, sorry, are there two types of map? Is one a water main map, and the other a sewage map?
Can I turn behind? I don't know the answer to that question, I'm afraid, my lord. Can I turn behind? Because
Okay,
there are
yeah.
people who will know the answer. That's just the sewer map, I'm told, my lord.
The sewer map, so not the water main map,
No.
albeit the water, it's described as the water main map, I think, in 3.1.
And what I don't know is whether, and this is the document
must
proposed
be
by the
another
claimant,
map.
whether we've got the whole thing, or whether irrelevant parts were omitted.
Okay.
Now, you were going to make, was it all right?
Yeah, yeah, sure.
You were going to make a point about the notes
Well,
on 1.3 and what and the guidance on over page 98.
the reason I was going to say that the contents of this search are more than so what is, again, in answer to a point that my Lord Justice Snowden made earlier. Part of the reason that the scheme of charging occupiers works is precisely because on conveyancing you ask about, you standardly ask about arrangements for surface water drainage. So people on purchasing their property have an opportunity to discover whether or not they should be correctly charged. I mean, I'm not sure it strictly goes to any part of the analysis, but it may do something to.
So the whole scheme of the whole scheme of the questions is part of the scheme of the questions is for the purchaser to work out who he's liable to.
Indeed, my lord.
And in terms of the evidence before the judge, he obviously had this, or there's some documentation relating to this later purchase, but no documentation relating to Brendon's original purchase.
He didn't, and that's the second matter I was going to come on to, my lady, because in my submission, that presumably would have been in the same form and asked the same question. So the same issue that I'm going to come on to in a second.
Well, it was the same form?
Well, the same.
There would have been a similar
There
process.
would have been a similar process, yes.
Okay.
And the third matter, I'm afraid with time, I'm not going to ask you to turn up. It's referred to in my skeleton argument. It's an email from 2018, which refers to a conversation in 2006. I think timing-wise, I will concentrate on the first two.
Without wishing to have a pun, this is the high watermark of your case on limitation.
This is the high watermark of the case, yes, my lord. Can I come on to the judge? Well, let me just address why I say it's the high watermark. This in question 4.1 directly identifies the issue about which there was said to be a mistake. What is the basis for charging for surface water drainage? It says, in terms, please refer to vendor or pre-contract documentation. Mrs. James's evidence was that she didn't read that and therefore didn't pick up on it. Had she read it, and she accepted this in cross-examination, had she read it and asked her solicitor about it, on the claimant's case, the correct advice for the solicitor to have given, after whatever investigations were necessary, was, actually, there's no basis for it. United Utilities have been making a mistake here. There isn't a public sewer near you. Had that advice been given, she would have discovered the mistake in 2009. Now, for the claimant to get round the limitation problem that poses for them, they would have to argue that reading this document on the conveyance and asking the solicitor to advise on a point identified for uncertainty constituted not reasonable diligence, but in the language of Paragon, exceptional measures. And in my submission, to say that a party in conveyancing should be, to describe a requirement that a party in conveyancing read search documents as exceptional measures would be, and I hope your Lordship will forgive me if I put it highly, but it would be entirely inconsistent with the general approach that English law takes to property transactions.
Where somebody is instructing a solicitor, does reasonable diligence encompass what the solicitor should have done? I mean, in a sense, this argument has gone through the lay client and the lay client's attitude or busyness or otherwise. But if you, as a lay client, employ a solicitor and a reasonably diligent solicitor would have picked up on that answer, in a sense, does that not, how does that factor into this compliance?
Well, one might say in the first place that you were fixed with what your agent did, but in my submission, I don't think that the court has to go there, because we didn't have any evidence from Mrs. James as to the respective responsibilities of her solicitor. I mean, if the solicitor had sent a letter saying, don't worry, I'm going to handle all this, ignore it, I've got this in hand, that might have raised different considerations. That wasn't this case.
No, but, sorry, I mean, if the question is with what would have been discovered with reasonable diligence by the party, if the party is instructing a solicitor, do you not ask the question of what a reasonably diligent solicitor would have done? If the reasonably diligent solicitor would have, of their own motion, because this is, on the face of it, seems to be an inquiry from them, which was answered to them. If a reasonably diligent solicitor would have done something on the back of it, then isn't that?
Well, on the face of things, as I say, they would be stuck with what their agent did. But in my submission, the court doesn't even have to go there because it was reasonable diligence would encompass Mrs. James reading this of her own accord and asking for advice on it. I'm being a bit nervous, I'm afraid, my lord, because I confess I've not looked to see whether there's authority on the extent to which you can stick a claimant with knowledge in that situation. So I don't want to say anything.
Yeah, you're not seeking to rely on the involvement of solicitors to effectively raise the bar and require further.
A high level of diligence.
I'm not, my
further
lady.
diligence.
I'm not.
You're saying Mrs. James should have read it and should have asked questions.
Exactly, my lady.
And applying Lord Justice Mell's question of were they being reasonably attentive, you would say that the answer to that question required attention.
It requires you to read a document produced in the course of conveyance.
Okay, but this, of course, is also a matter which turns on the judge's evaluation of the evidence, which
and
we're now going to come to.
We're now going to come to that because what the judge, in my submission, the judge made what can be seen to be a straightforward error. Paragraph 116 of the judgment, we've seen 115, 116 he says, I have already found, however, that the claimant did not discover the mistake until February 2018 and had not been put on inquiry as to the mistake before that date. So he's referring back to an earlier finding. And to see what that finding is and why it is simply not adequate to deal with the question under 32, section 32, one has to go back to page 103. Bottom of that page, did your lordship see there's a heading payment under a mistake?
Yes.
And he comes on from these in this section to deal with the question of whether or not there was a mistake. And he sets out some law at 99. Paragraph 100 he sets out the claimant's case. In paragraph 101 he sets out the defendant's case on the question whether there was a mistake. And he identifies correctly that we took 3 points. The first is that we put the claimant to proof as to whether there was a positive belief as opposed to simple ignorance. The second, this is about halfway down the paragraph, we took a point about doubt may prevent a mistake from being found. And the third point we took, and this is the last sentence, is that a deliberate waiver of inquiry when put on notice can preclude recovery. And can I, just to demonstrate what that defence involved, go to just one paragraph, or 2 paragraphs maybe, in the Derby case that the judge correctly refers to, which was paragraph 16 of the first volume of the authorities. Paragraph 23. This Robert Walker, Lord Justice Robert Walker's judgment. In his judgment, the judge referred at some length to Kelly and Solari, and he may be taken to have recognised that deliberate waiver of inquiry, where there are circumstances which put the pair on inquiry, will preclude recovery. And then the final sentence of paragraph 24.
Well, deliberate waiver of inquiry or acceptance which is not to be equated with carelessness or negligence is the last sentence.
Indeed, and the judge, Lord Justice Robert Walker, makes the same point in the final sentence of paragraph 24. Sorry, the final 3 sentences of paragraph 24. The judge was making a contrast between carelessness, however culpable, and the situation where the paying party is on inquiry, but consciously decides to pay without making further inquiry. So deliberate waiver of inquiry and the test under section 32 can be contrasted in a number of ways. Deliberate waiver of inquiry has to be deliberate. So that means you've got to be conscious of the point to inquire, and you've got to consciously fail to do anything about it. And it's emphatically not sufficient for that you are careless. It's not about carelessness. It's a definite decision not to inquire. Whereas section 32 is not about your actual state of mind, it's what the reasonably attentive person would have realised. And it's a lower test even than carelessness. It's whether, and this is why I went to that passage from Paragon, it's about whether you could have discovered the mistake, not whether you should.
So he applied a test applicable to the law of mistake instead of the law applicable to
Law of lim-
limitation.
Indeed, and given the time, I'm not going to go through all the paragraphs, but in the following paragraphs, he undertakes an assessment of Mrs. James's subjective state of mind, and that's clearly the task that he was correctly involved on at that stage. But he does not undertake any objective about what the reasonably attentive person would have realised. And then he reaches his conclusion at paragraph 112.
Yeah.
And what he says
I
there.
thought Lord Justice Mail says it's about whether the particular person would, with reasonable care, have discovered, could have discovered.
Indeed. So what the point of the first rider is that you have regard to the actual position of the claimant. So you don't sort of posit some particularly well-informed person.
Yeah.
It's a person in the actual position of the claimant. But then when you go on to ask what knowledge should they be fixed with, you apply a standard of reasonableness. You don't look at their actual subjective knowledge. And then the judge reaches his conclusion on these matters of subjectivity.
Sorry, I'm not sure. You actually do look at what they actually knew, and then ask the question: what would a careful person with that state of knowledge?
Yes, my lord. So the point I was endeavouring to avoid any confusion about, and failing to avoid confusion, is that when you ask, are they on inquiry for the purposes of Section 32, that's not determined by what is subjectively in their mind. It's what the reasonably attentive person would be aware of.
Yes. So a letter that you haven't read but should have read.
Yes.
Is
Then deliberate waiver of inquiry you'll fail on, as I did.
But
here.
in working out whether you should have read it, you do take into account the personal circumstances of the individual.
You do.
So if you're dealing with an individual, well, okay,
here a corporate entity.
corporate entity, and it may be the advice point that the law was raising with you is relevant to that point. Now you want to make a point about 112.
12. And this is where the judge then says, he does two things in this paragraph. First sentence, he finds there was no state of doubt, so he's dealing with my second line of defence. And the third sentence, he says, I do not consider that at any point before that it had been put on notice that it might not be liable in a way which required it to make inquiries which it had deliberately chosen not to undertake. And that is the earlier finding that the judge refers back to at paragraph 116. But that finding in my submission is quite clearly a finding on the deliberate waiver test. And I say that for three reasons. It's just the language that the judge uses. He talks about deliberately chosen not to undertake. And indeed it's language which is entirely inapt to describe the Section 32 test, because as I've endeavoured to show, the Section 32 test has nothing to do with the word required. That would be utterly inapt in the context of Section 32.
Had you actually, in your argument, raised the reasonable inquiry, could with reasonable diligence have discovered point?
Yes, I had. And the judge takes the point that the deliberate waiver of inquiry point, he takes the point that it wasn't pleaded, which it wasn't. Section 32 was always pleaded from the outset. And that was taken squarely in front of the judge. And indeed, I recall in the course of argument, I picked the judge up on using the term negligence.
Yeah, I mean, it's just
it's not a standard of negligence.
It's just he doesn't actually mention it in 101, does he?
Well, that he's entirely correct to do
That's
so.
what he's doing a mistake there.
Precisely, my lord. That's entirely my point, my lord.
He's allied mistake and implementation.
Exactly.
Okay, all right. You were making 3 points. One, deliberate.
Wrong language, so clearly
Wrong
dealing
language,
with deliberate.
yes.
Secondly, in fact, your lordship's point just now, it's the section of the judgment is dealing with mistake, not limitation. And thirdly, all the substantive analysis that leads to it is based on subjectivity, not objectivity.
All the language he uses.
Indeed. So in my submission, it is entirely clear that the judge has confused the two tests and as a result been too generous to the claimant on the question of limitation, and his assessment can't stand. I also make the point in my skeleton argument, which I don't have time to develop, but which I stand by, that if I'm wrong about that, he applied the correct test, he's failed to give adequate reasons. In particular, he doesn't adequately deal with that question 4.1. He deals with the earlier question.
It's just dealt with in paragraph 116. That's where he deals with that point. Deals with the whole question. That's his conclusion.
He does. I mean, my learned friend might say that earlier passages deal. Well,
You'll come back to
I'll
that.
come back
Okay,
with that if
fine.
I've got to.
All right. Well, it's just gone 1 o'clock. Yes.
A very small point. I didn't want to drop my learned friend before. He said that the evidence was that Mrs. James hadn't read the 2009 report. Can I just refer you to paragraph 107 of the judgment, where it is stated that evidence was she was saying. Mrs. James made it clear she was not saying that she had not read.
Okay. Well, you can develop all that after lunch. If you find there are any points that you think you should make, and briefly at 2 o'clock, then of course we'll let you. Otherwise, we look forward to hearing what Mr. Steinmetz has to say in reply or in response. Thank you very much. 2 o'clock.